Until recently, the world of technology and the law rarely met. It was very hard for technologists, techies, to understand the intricacies of the law, and for lawyers to understand technology. But digital technology has penetrated deep in our lives and has forever altered how we live, how we work, how we do business, how we communicate, how we how we purchase, how we find our partners, how we share with the world what we ate for lunch. The future, as Richard Susskind said in his books, Tomorrow's Lawyers, the future demands lawyers who are as comfortable reading court cases as they are writing Python. The Africa Law Tech Festival is a unique festival that has strengthened these two worlds, technology and the law. And over the last few days, there have been debates on how these two can relate and what challenges exist between the two. Just last week in Kenya, the civil procedure rules were amended to provide for service by electronic email, which has been done in many jurisdictions before. But we already argue for legal practitioners what this would mean, what it means for service, what it means for law clerks. Technology has enhanced access for justice through the digitization of courts and court records. And this is more important in our continent where there are few courthouses and so many people are remote from those spaces. What would we need to do to ensure that someone in Turkana does not need to travel to a courthouse in Eldoret or in Kisumu to give evidence? You also agree that in this century, civil action is no longer about going to the streets. Civic movements and crimes are both being fueled through online platforms. When the Bill of Rights was first codified, freedom of expression and freedom of assembly was about working in physical spaces. Now it no longer is. It is about what space has been opened up on online platforms and through our mobile phones. And that is what we need to protect as lawyers and to be wary of the dangers that exist if we don't codify properly the use of technology. So we must reevaluate our focus and the approaches and shift our interventions. There are many legal dilemmas in the space of emerging technologies. There are many legal black holes, and there is need for techies and lawyers to debate the necessary changes and disruptions that will reflect modern reality. The balance between the right to privacy, surveillance, data collection, production of evidence, and all the other things that we need to do to ensure an open space and an open society. We must also not forget the existing inequalities in the access to technology, where the scales are shifted and tilted in favor of government and businesses. And we cannot ignore that this is likely to exacerbate the circumstances of the marginalized, whether they are marginalized because of their gender, their economic status, their disability, or the part of the world that we come from. So we recognize these limitations as jurists on technology. And in the last ICJ Kenya annual jurist conference, the jurists were heard to say, technology confounds us. Or if you're really bad in technology, you study the law. However, the reality is there is need for technology experts to work with legal experts and policymakers. And at ICJ Kenya, we are committed to keep track of the impact of tech revolutions, to learn and to engage, and to be at the forefront in ensuring that law and policy can keep up. So I must thank the Lawyers Hub and all the other partners who've put this festival together, and for which ICJ Kenya is proudly to be associated. Asanteni.